Have you ever wondered what would happen to your hard-earned assets and properties after you pass away? How can you ensure that your loved ones are taken care of according to your wishes? The answer lies in understanding the concept of wills under Philippine laws. In the Philippines, the laws governing wills are found in Articles 783 to 795 of the Civil Code. This topic is one of the frequently asked subjects in the Philippine Bar Examination, reflecting its importance in the legal field. So, whether you're a law student, a practicing lawyer, or simply someone who wants to ensure your assets are properly distributed, understanding wills is crucial. Subscribe to our channel to stay updated with more informative legal content like this. Part 1. Definition and importance of a will. A will, also known as a last will and testament, is a legal document that outlines a person's wishes regarding the distribution of their assets and properties after their death. It is a powerful tool that allows individuals to exercise their right to decide how their estate will be managed and divided among their beneficiaries. In the Philippines, having a valid and enforceable will is essential for several reasons. First, it ensures that your assets are distributed according to your specific desires, rather than being subject to the default rules of intestate succession. Second, it can help minimize conflicts and disputes among family members or potential heirs. Third, it provides a way to name guardians for minor children and make provisions for their care and upbringing.
Part 2. Requirements for a valid will in the Philippines. Under Philippine laws, for a will to be considered valid, it must meet certain requirements outlined in the Civil Code. These requirements include a testamentary capacity. The person making the will, testator, must be of legal age, at least 18 years old, and of sound mind at the time of executing the will. The freedom of action. The will must be executed freely, without any undue influence, fraud, or violence. C. Formalities. The will must be in writing and follow specific formalities depending on the type of will. There are two main types of wills recognized in the Philippines. A. Notarial will. This type of will must be acknowledged before a notary public by the testator and signed by the latter, as well as by at least 3 credible witnesses in the presence of the testator and the notary public. 2. Holographic will. This is a will entirely handwritten, dated, and signed by the testator themselves. No witnesses are required for this type of will. D. Revocation. A validly executed will can be revoked or modified by the testator through a subsequent will, a written revocation, or by performing specific acts that imply the intention to revoke the will.
Part 3. Distribution of estate and shares of compulsory heirs. In the Philippines, the distribution of a person's estate is governed by specific rules outlined in the Civil Code. These rules aim to balance the testator's freedom to dispose of their assets with the rights of their compulsory heirs. Compulsory heirs are individuals who, by law, are entitled to a specific portion of the testator's estate, regardless of the provisions of the will. These include A. Legitimate children and descendants, B. Legitimate parents and descendants, C. Surviving spouse. The shares of compulsory heirs are determined based on their relationship to the testator and the presence or absence of other compulsory heirs. Generally, the shares are as follows. If the testator has legitimate children or descendants, they are entitled to 1/2 of the estate. If there are no legitimate children or descendants, but there are legitimate parents or ascendants, they are entitled to 1/2 of the estate. If there are no legitimate children, descendants, or parents, the surviving spouse is entitled to 1/2 of the estate. The testator can freely dispose of the remaining portion of their estate, known as the free disposable portion, subject to the rights of the compulsory heirs. It's important to note that the testator cannot disinherit their compulsory heirs entirely, except in specific circumstances outlined in the Civil Code, such as when the heir has committed certain grave offenses against the testator. Part 4. Probate proceedings and administration of the estate. After a person passes away, there must go through a legal process known as probate. This process involves the following steps. A. Petition for probate. The executor named in the will, or any interested party, files a petition for probate with the appropriate court, typically the regional trial court in the area where the testator was a resident at the time of their death. B. Notice to heirs and creditors. The court issues a notice to all potential heirs and creditors of the deceased, informing them of the probate proceedings and allowing them to file any claims or objections. C. Hearing and examination of the will. The court holds a hearing to examine the validity of the will, considering factors such as the testator's testamentary capacity, freedom of action, and compliance with formalities. D. Appointment of an administrator or executor. If the will is found to be valid, the court appoints an administrator or executor to manage and distribute the estate according to the provisions of the will. E. Distribution of assets. The administrator or executor is responsible for locating and inventorying the assets of the estate, paying any outstanding debts or taxes, and distributing the remaining assets to the designated beneficiaries in accordance with the will. F. Final accounting and discharge. Once the distribution is complete, the administrator or executor must submit a final accounting to the court and request a discharge, officially closing the probate proceedings. Understanding the laws and processes surrounding wills is crucial for ensuring that your assets are distributed according to your wishes after you pass away. Subscribe to our channel to stay updated with more informative legal content like this.
Part 5. Frequently asked questions. 1. Can a will be contested or challenged in the Philippines? Yes, a will can be contested or challenged in the Philippines under certain circumstances, such as if there are allegations of undue influence, fraud, or lack of testamentary capacity. The process for contesting a will involves filing a legal action with the appropriate court. 2. What happens if a person dies without a will in the Philippines? If a person dies without a valid will, known as intestate, their estate will be distributed according to the rules of intestate succession outlined in the Civil Code. This means that their assets will be divided among their legal heirs based on a predetermined order of succession. 3. Can a foreigner make a will that is valid in the Philippines? Yes, foreigners can make a will that is valid in the Philippines, provided that it complies with the requirements outlined in the Civil Code, such as testamentary capacity, freedom of action, and proper formalities. However, it's advisable to consult with a Philippine lawyer to ensure that the will is properly executed.
Part 6. Bar exam question number 1. Alfonso, a bachelor, without any descendant or ascendant, wrote a last will and testament in which he devised all the properties of which I may be possessed at the time of my death to his favorite brother Manuel. At the time he wrote the will, he owned only one parcel of land. But by the time he died, he owned 20 parcels of land. His other brothers and sisters insist that his will should pass only the parcel of land he owned at the time it was written, and did not cover his properties acquired, which should be by intestate succession. Manuel claims otherwise. Who is correct? Explain. 1996 Bar. Answer. Manuel is correct because property acquired after the making of a will shall only pass thereby. As if the testator had possessed it at the time of making the will, should it expressly appear by the will that such was his intention. since Alfonso's intention to devise all properties he owned at the time of his death expressly appears on the will, then all the 20 parcels of land are included in the devise. Bar exam question number 2. Rick and Josie, Filipinos, have been sweethearts for 5 years. While working in a European country where the execution of joint wills are allowed, the two of them executed a joint holographic will where they named each other as sole heir of the other in case either of them dies. Unfortunately, Rick died a year later. Can Josie have the joint will successfully probated in the Philippines? 2011 Bar. A. Yes. In the highest interest of comity of nations and to honor the wishes of the deceased. B. No, since Philippine law prohibits the execution of joint wills and such law is binding on Rick and Josie even abroad. C. Yes, since they executed their joint will out of mutual love and care, values that the generally accepted principles of international law accepts. D. Yes, since it is valid in the country where it was executed, applying the principle of lex loci celebrationis. A. B.